So let me ask this. What can I, as a protester, do about the police holding information on me?
So this is an issue which has become increasingly important year on year. For a number of years, we've heard about police databases. There's been the domestic extremism database, which was the database held on protesters who were believed to be willing to break the law to further their protest. The idea of that's been around for years and years and years. But as technology has increased, the ability for the police to hoover up large amounts of data and to keep it in a way which is actually accessible to them. This is as opposed to days of old when it would be notebooks and then added in maybe onto a database somewhere. This is really usable data. It's something that clients ask us about every single time we do a complaint involving protesters or a compensation claim involving protesters is, how can I get rid of my data? And recently we've had the Data Protection Act 2018, which brought into effect something called the General Data Protection Regulation. You may have heard of it as the GDPR. The GDPR has really strengthened the rights that we have to accessing our data, to correcting our data, but more fundamentally, it's changed it from a situation where organizations, when collecting data, had to do it fairly and accurately and for the right purposes, to the whole idea of, well, do you really need this data in the first place? And so there's a much better way of getting in and challenging the right of the police to keep that data, to obtain it and then to retain it at all, and also to disseminate it, to pass it out to other organizations. So the GDPR is very detailed, very lengthy, but basic issues. A person has the right to be informed about the collection of their personal data, told how it's being used, how it's being shared, who with, for how long it be kept. It can only be collected for lawful purposes and should be minimum and relevant, etc. So it's very much strengthened, and that's helpful. So what you can do about it, though, is really the first thing is we've got to find out what data the police hold on you. So you can make a data access request. This is a free process where you write to the police, and there's usually a form on their website which you fill in, give the information that is necessary in order to make sure that you are the person accessing your data. And you can ask for things, whether that's custody records or entries about your attendance at a protest and so on and so forth. Now, that can be quite detailed. I've had it before with a client, and we had a whole lever arch file of endless entries of protests that he'd attended and so on and so forth. And that really helped build up a picture of how they viewed him, and we could use that in a subsequent civil claim to talk about a somewhat obsessive interest they had in him. Obviously, where the police are collecting data, there are times when they will have a lawful basis for that. And so there are many exclusions that they can rely on to either not confirm or deny whether they hold that data, or to redact certain parts of it. It can be quite difficult to get down deep into any intelligence, for instance, but you can get a good idea of things, and then you can also challenge whether it should be kept anymore. So recently there was the case of John Catt, which I say recently, started many years ago, but has finally been resolved in the European Court of Human Rights. And John Catt was a protester who had a sort of very on the edges involvement with an organisation who were themselves involved in direct action. And he attended a lot of protests. He was on the edge of this organisation to some extent. He was also quite elderly and was not involved in the direct action. Everybody agreed with that. But the police kept enormous amount of information on him and used that information to keep tabs on him, not just when he was at those protests, but if he was going elsewhere, and also in relation to his daughter. And he challenged their right to keep that data at all, and also over many years. And finally, this went back and forth through the High Court, the Court of Appeal, the Supreme Court, and finally the European Court said, confirmed that collection and processing of such information from public spaces, this was kind of political information, must be regulated by law and limited to what is necessary and proportionate to achieve a legitimate aim. And furthermore, when considering data on a person's political views, which is a special category data under the GDPR, the court stressed the need for a heightened level of protection. How this is going to change things is not yet really clear. The police have, made some positive noises about reviewing data, etc. But really, unless activists are willing to challenge the data that is held on them and to pursue it and to find out what is there, we're not really going to know what we can do about that data, and more importantly, what the police are doing about that data. So you can get it changed through that data access request process if you can challenge the relevance, the accuracy of that data. The other way that we do it is through compensation claims, and when we have been successful in settling somebody's claim for a wrongful arrest, we often can get the data cleaned up or deleted. And there are other processes available. It's worth protesters finding out what data is there on them and trying, where possible, to challenge that. It is, as the court said, political views are special category data. They shouldn't be held, they shouldn't be retained and held unless really necessary. And ultimately, retention inevitably is going to have a chilling effect on people's involvement in protest. So the more that protesters can stand up and challenge that, the better for everybody.
Thanks. You mentioned John Catt's claim and how long that took, going all the way from the High Court up to the European Court. And I think it was getting close to a decade from when he first put the application in to find out what information they had about him until it was finally resolved. But obviously now that has been resolved, and in a way which helps all protesters. But just on timeframes, what's the normal sort of time frame for putting in an access request and getting a response from the police? Or is it how long's a piece of string?
Well, it is how long is a piece of string, because it depends on the information you've asked for, and B, it's a huge amount down to resources that the police are willing to put into it. There is a nominal, and I say nominal, statutory limit of 40 days. That is routinely passed, and the police now have a pretty automated process of sending out a letter of apology saying that it will be delayed, and complaints have been made to the Information Commissioner's office. Sometimes they're helpful, but the ICO recognise that the police are under-resourced in this particular area. It's not something that the police are particularly enthusiastic about doing, and through austerity and at times when there are other policing pressures like our recent pandemic, those offices tend to get further under-resourced, and it can take months and months and months to get your data back. It is worth pursuing, and for instance, there's a very helpful set of letters on the Network for Police Monitoring website, which explains the process, albeit under what was the subject access request then before this new act, but it's the same routine, same regime, really. And they have some good standard letters there, so you can keep the pressure on trying to get the data that you've been asking for.
And stick with it. Fantastic. Thank you very much.
Not at all.